Hey guys! Tonight we begin with two men standing before the same judge accused of the same crime. They have both stolen bread. Not metaphorical bread, not the bread of labor exploitation or systemic inequality, but actual loaves of wheat bread from a baker's stall in a market town in medieval England. The evidence against them is identical. The baker caught them both. Witnesses saw them both. They have both confessed, because denial is pointless when you are literally holding the bread. The judge looks at the first man, a laborer in rough wool, and sentences him to 20 lashes at the public post. The judge looks at the second man, a merchant's son in decent cloth, and sentences him to pay 12 pence. Both men stole bread. One walks away with welts that will scar his back for life. The other walks away with a lighter purse. Welcome to medieval justice, where your wallet could literally save your skin. This is not a story about corruption, though corruption certainly existed. This is a story about how medieval and early modern legal systems formally, officially, and quite openly allowed certain crimes to be punished with fines instead of corporal punishment, and how this created a two-tiered system of justice that persists in modified forms to this day. The principle seems obviously unjust to modern sensibilities. If a crime deserves physical punishment, surely everyone who commits it should face that punishment equally. If a crime can be adequately addressed through a fine, surely the fine should be the standard penalty for everyone. The medieval mind saw things differently, and understanding why requires us to abandon some of our assumptions about what punishment is supposed to accomplish. Before we go further, let me ask you something. If you are the kind of person who finds yourself watching videos about medieval punishment systems at whatever hour it is where you are, you have found your people. Consider subscribing if you want more of these explorations of how past societies organize themselves in ways that seem alien until you realize they aren't as alien as you thought. I would love to know what time it is where you are and what brought you to this topic tonight. Is it the legal history, the class dynamics, the simple morbid curiosity about who got whipped and who did not? Tell me in the comments, because I genuinely read every single one. The system of substituting fines for corporal punishment has roots that stretch back to the earliest recorded legal codes. The laws of Hammurabi, carved in stone nearly 4,000 years ago in ancient Babylon, already contain provisions for financial compensation as an alternative to physical retribution. An eye for an eye sounds absolute, but the actual text is more nuanced. If a man destroys the eye of another man of equal status, his eye shall be destroyed. But if a man destroys the eye of a commoner, he shall pay 1 mina of silver. The principle of proportional physical retaliation applied only between social equals. Across class lines, money could substitute for flesh. Babylon had figured this out before most of Europe had figured out writing. The Germanic tribal codes that shaped early medieval European law took this principle even further. The concept of wergild, literally meaning man payment, established explicit monetary values for human lives based on social rank. If you killed a nobleman, you owed his family a sum that might bankrupt a village. If you killed a peasant, the payment was dramatically less. If you killed a slave, you compensated the owner for lost property. These were not bribes or corruption. They were the formal, recognized legal framework for how society handled violence. The purpose was not justice in the abstract sense, but rather the prevention of blood feuds. Pay the family, and they have no legal right to kill you in return. Refuse to pay, and they can pursue vengeance legitimately. The early English legal tradition absorbed these Germanic principles and developed them into an elaborate system of fines and compensations that coexisted with corporal punishment. The Anglo-Saxon law codes list prices for various offenses with the specificity of a restaurant menu. Breaking someone's front teeth costs more than breaking their back teeth because front teeth are more visible and their loss more shameful. Cutting off a thumb costs more than cutting off a little finger because thumbs are more useful. The nose costs more than the ear. The eye costs more than the nose. Every body part has its price, and that price varies depending on the social status of both victim and perpetrator. What happens, though, when the perpetrator can't pay? This is where corporal punishment enters as the poor man's alternative. A wealthy man who commits assault pays his fine and goes home. A poor man who commits the same assault but can't pay faces the lash, the pillory, or worse. The punishment is not technically different because of class. It is technically different because of financial capacity. The law treats everyone equally by offering everyone the same choice: pay money or receive pain. That the choice is meaningless for those without money is a feature, not a bug of the system. Let us examine a specific case to understand how this worked in practice. In 1285, a man named William the Cooper appears in the records of a manor court in Suffolk. He's accused of brewing ale without a license, a common offense that violated the lord's monopoly on brewing rights. The standard punishment for this offense is a fine of 6 pence, which William can't pay. The court records note that because William lacks the means to satisfy his fine, he shall instead receive 6 strokes of the rod in the marketplace. A woman named Agnes, accused of the same offense at the same session, pays her 6 pence and disappears from the record. Both brewed illegally. Both appeared before the same court. One was beaten publicly. One was not. The manor courts, those local tribunals that handled the bulk of medieval English justice, developed elaborate conversion tables between money and pain. A 6-pence fine might equal 6 strokes. A shilling fine might equal 12 strokes, or a period in the stocks. Larger fines might convert to multiple whippings spread across several market days, giving the offender time to recover between sessions while ensuring that the community witnessed each installment of their punishment. The mathematics of suffering was calculated with bureaucratic precision, ledgers of pain maintained alongside ledgers of income. The church added its own layer of complexity to this system. Ecclesiastical courts, which handled matters of morality, marriage, and religious observance, also employed fines and corporal punishment, but with an additional option that was uniquely medieval: penance. A sinner could escape both fine and beating by performing public acts of humiliation and devotion, walking barefoot through the marketplace while confessing one's sins, standing at the church door in a white sheet while the congregation filed past, crawling on one's knees around the parish boundary. These penances cost nothing financially, but exacted a price in dignity that some found worse than either money or pain. The wealthy generally preferred fines. The poor often preferred penance, which at least left no scars. The calculation of shame versus suffering versus expense occupied considerable mental energy for those navigating the medieval justice system. A merchant might pay a fine rather than have his business associates see him in the stocks. A peasant might accept public penance rather than lose the labor capacity that a beating would temporarily destroy. A knight might accept neither fine, nor penance, nor beating, invoking instead his right to trial by combat or benefit of clergy. The system offered choices, of a sort, calibrated to extract maximum compliance from each social stratum. Speaking of benefit of clergy, this represents one of the most remarkable loopholes in the history of criminal justice. Originally, ecclesiastical personnel, meaning priests, monks, nuns, and other religious figures, could not be tried in secular courts. They answered only to church courts, which could not impose death sentences or serious corporal punishment. Over time, the definition of clergy expanded to include anyone who could demonstrate basic literacy, on the theory that only educated church people could read. Prove you can read a verse of scripture, typically Psalm 51, and you escape the secular court's jurisdiction. This was called the neck verse because reciting it could literally save your neck from the hangman. The result was that literate criminals, who were also generally wealthier criminals, could escape corporal and capital punishment for their first offense by claiming benefit of clergy. They would be handed over to church courts, where the maximum penalty was typically branding on the thumb, a painful but non-lethal mark that prevented them from claiming the benefit again. Illiterate criminals face the full severity of secular justice, including hanging for offenses that their educated counterparts survived. The ability to read literally made the difference between life and death, and reading ability correlated strongly with wealth and social position. The conversion between fines and physical punishment was not always one-directional. In some cases, particularly serious crimes, even wealthy offenders faced mandatory corporal or capital punishment that no amount of money could avoid. Treason, for example, required execution regardless of the traitor's ability to pay. Murder of a social superior often demanded death. Certain forms of theft, particularly theft from churches or the royal household, carried mandatory physical penalties. These exceptions served to reinforce the gravity of certain offenses while also ensuring that the powerful could not simply buy their way out of all consequences. But for the vast middle range of offenses, the ones that made up the bulk of medieval court business, the fine or flesh option remained standard. Consider the assizes of ale and bread, the regulations that govern the quality and pricing of basic foodstuffs. Bakers who sold underweight loaves or brewers who watered their ale faced fines that most established tradespeople could pay. Those who could not pay faced the pillory or the cucking stool, public humiliations that served the dual purpose of punishment and entertainment for the community. The wealthy baker paid and continued baking. The poor baker suffered publicly and then continued baking, because what else could he do? The system tolerated a certain amount of low-level commercial fraud as long as the perpetrators paid their taxes on it. The royal courts operated on similar principles, but at a grander scale. The king's justice was theoretically supreme, overriding local customs and manorial privileges, but it was also expensive to access. Bringing a case before royal judges required fees at every stage: fees to file, fees to summon, fees to delay, fees to decide. A litigant of means could navigate this system and potentially secure favorable judgments. A litigant without means could barely enter the system at all. The royal courts technically offered more sophisticated justice than local tribunals, but that sophistication was available primarily to those who could afford it. When royal justice did reach the poor, it often arrived in the form of harsh corporal punishment for offenses that wealthier defendants resolved financially. Poaching from royal forests, for example, could result in maiming, blinding, or death for peasants caught taking game. Noble hunters who exceeded their privileges faced fines, confiscations of hunting rights, perhaps temporary banishment from court. The deer belonged equally to the king, whether taken by peasant or peer, but the consequences for taking them varied enormously based on who did the taking. Let us consider a specific category of offense that illustrates these dynamics with particular clarity: debt. In the medieval period, the inability to pay one's debts was not merely a civil matter, but could become a criminal one. A debtor who refused to pay, or who was deemed to have refused by being unable to pay, could be imprisoned, beaten, or subjected to various humiliating punishments designed to pressure them into finding resources they might be hiding. The law assumed that debtors were frauds who possessed hidden wealth. The reality that poverty might simply prevent payment was acknowledged, but not accommodated. Wealthy debtors, by contrast, could negotiate. They could offer partial payment. They could pledge future income. They could transfer property. They could invoke the protection of powerful patrons who would guarantee their obligations. A nobleman in debt might lose estates, but keep his freedom and his skin. A peasant in debt might lose everything, including his bodily integrity, and still owe the debt when he emerged from prison months or years later. The system was not designed to collect debts efficiently. It was designed to demonstrate the consequences of failing to meet obligations to one's betters. The continental European systems developed variations on these themes, some more brutal and some more sophisticated. The Italian city-states, with their advanced commercial economies, created elaborate systems of commercial justice that protected merchants from the harsher aspects of criminal law. A Florentine banker who defaulted might face bankruptcy and social disgrace, but rarely faced corporal punishment. A Florentine laborer who stole from that banker faced the lash, the brand, or worse. The commercial classes had successfully carved out legal protections for their characteristic offenses, while maintaining harsh punishment for offenses associated with the lower orders. France developed the concept of amende honorable, a public apology and submission that could substitute for physical punishment in cases involving honor and reputation. A gentleman who slandered another gentleman might be required to kneel, apologize, and pay damages, but would not be whipped like a common criminal. A peasant who slandered a gentleman faced the full weight of defamation law, which could include tongue-boring, branding, or public beating. The offense was technically the same. The punishment varied based on who was offending whom. The Holy Roman Empire, that magnificent chaos of overlapping jurisdictions, developed perhaps the most complex system of fine versus flesh calculations. The Carolina, the criminal code promulgated by Emperor Charles V in 1532, attempted to standardize punishments across the empire while still preserving the traditional privileges of various estates. The result was a detailed schedule of penalties that read like a price list for pain. Theft of goods worth less than 5 gulden? Whipping. Theft of goods worth more than 5 gulden by someone who could pay restitution? Fine and banishment. Theft of goods worth more than 5 gulden by someone who could not pay? Hanging. The value of the stolen goods and the capacity of the thief together determined whether they lived or died. Spain, under the Habsburgs, developed particularly elaborate distinctions between punishments for different social classes. The hidalgos, the minor nobility who formed a significant portion of the Spanish population, could not be subjected to many of the punishments that applied to commoners. They could not be tortured judicially. They could not be whipped. They could not be sent to the galleys except for the most serious crimes. Instead, they faced fines, exile, and imprisonment in conditions appropriate to their station. A hidalgo and a peasant might commit identical crimes, but only one would feel the lash. The English common law tradition, with its cult of precedent and gradual evolution, developed its own characteristic approaches to the fine or flesh question. The Statute of Laborers, enacted after the Black Death to prevent workers from demanding higher wages, prescribed different punishments for different classes of offender. Lords who paid excessive wages faced fines. Workers who demanded excessive wages faced imprisonment and physical punishment. The offense was two sides of the same transaction, but the law treated employer and employee completely differently. As the medieval period gave way to the early modern era, the substitution of fines for corporal punishment became, if anything, more systematic. The Tudor and Stuart monarchies, always short of revenue, discovered that criminal justice could be a profitable enterprise. Minor offenses that might once have been punished physically were increasingly resolved through payments to the crown. The crown preferred money to satisfied vengeance. Defendants who could pay preferred payment to pain. The resulting system extracted revenue while maintaining the threat of corporal punishment for those without the means to buy their way out. The Elizabethan poor laws added another dimension to this calculus. Vagrancy, meaning the crime of being poor and mobile, was punishable by whipping for first offenders and by branding, ear boring, or death for repeat offenders. But the same laws that criminalized poverty also created mechanisms for the parish to support its own poor. A vagrant who could demonstrate settlement in a particular parish might escape punishment and receive relief instead. The question of whether poverty was a crime or a condition requiring assistance depended entirely on bureaucratic details of settlement and belonging. The early modern period also saw the development of transportation as a punishment, sending convicts to colonies where their labor could be exploited. This created a new option in the punishment hierarchy: death, corporal punishment, transportation, fine. A wealthy offender might pay to avoid transportation. A poor offender might be shipped to Virginia or later Australia, regardless of their preferences. The colonies needed labor, and the criminal justice system could supply it, but only by extracting the laborers from among those without the resources to buy alternative punishments. By the 18th century, reformers began to question whether the substitution of fines for corporal punishment represented a principled approach to justice or merely a mechanism for the wealthy to escape consequences. Cesare Beccaria, the Italian philosopher whose work on crimes and punishments helped launch the modern study of criminal justice, argued that punishments should be proportional to offenses and equal regardless of the offender's status. The idea that a rich man and a poor man should face the same consequences for the same crime struck many Enlightenment thinkers as obviously correct. It struck the existing legal establishment as dangerously radical. The American and French revolutions, with their rhetoric of equality before the law, challenged the traditional fine or flesh system at a fundamental level. The Eighth Amendment to the United States Constitution prohibits excessive fines and cruel and unusual punishments, implicitly recognizing that both money penalties and physical penalties could be abused. The French Declaration of the Rights of Man proclaimed that the law should be the same for all, whether it protects or punishes. These principles sound like obvious justice to modern ears. They were revolutionary challenges to centuries of established practice. But abolishing formal legal distinctions did not abolish the practical advantages that wealth conferred in the criminal justice system. A wealthy defendant in post-revolutionary America or France could still hire better lawyers, post bail more easily, and ultimately pay fines that would devastate a poor defendant. The substitution of fines for corporal punishment continued, now justified not by formal legal privilege, but by the neutral operation of supposedly equal laws. The rich man and the poor man were now equally forbidden to sleep under bridges and equally entitled to pay fines instead of receiving lashes. Formal equality coexisted with substantial inequality. In the next part of this story, we'll examine specific categories of crime where the fine versus flesh distinction operated most dramatically, from sexual offenses to property crimes to the peculiar category of offenses against public order. We'll meet individuals who navigated this system, some successfully and some not, and we'll begin to understand why reformers found it so difficult to create truly equal justice, even after they abolished the formal legal privileges that had made inequality explicit. The system was not merely unjust because of bad laws. It was unjust because of how money and power interact with any legal system, good laws or bad. The ledgers of medieval courts still exist in archives across Europe, recording with meticulous precision who paid and who suffered. These are not merely historical curiosities, but evidence of a legal philosophy that remains with us in modified form. When a wealthy defendant today pays a fine that represents pocket change, while a poor defendant faces consequences that reshape their entire life, we are seeing the descendants of the system that allowed some to pay 6 pence while others received 6 strokes. The conversion rate between money and pain has changed. The underlying calculation has not. The category of sexual offenses provides perhaps the clearest window into how the fine versus flesh calculation operated in medieval and early modern justice. Sex, after all, crosses class boundaries in ways that property crimes often do not. A nobleman might never steal bread, but he might very well commit adultery, fornication, or worse. The legal system had to navigate the awkward reality that high-status individuals committed the same shameful acts as low-status individuals, while still maintaining the fiction that status should determine punishment. The solutions they developed reveal more about the moral architecture of these societies than any theological treatise. Adultery, in the medieval understanding, was primarily a property offense. A married woman who slept with a man other than her husband corrupted the bloodline, potentially introducing illegitimate heirs into the family. A married man who slept with another man's wife committed theft of a particularly intimate kind. The severity of punishment depended less on the act itself than on the social positions of those involved. A peasant who committed adultery with another peasant's wife might face public whipping and a period in the stocks. A gentleman who committed adultery with a peasant's wife faced a fine payable to the aggrieved husband. The wife's body was damaged goods in either case, but the remedy varied based on who had done the damaging. When both parties were a high status, the system became even more creative in avoiding corporal punishment. A gentleman caught in adultery with another gentleman's wife might face enormous fines, social disgrace, challenges to duels, exclusion from court, loss of preferments in offices. What he would not face in most jurisdictions was the public whipping that a commoner would receive for the same act. His punishment was severe, perhaps more severe in some ways than the peasant's brief physical pain, but it operated through different mechanisms entirely. Money and status were extracted, flesh was spared. The ecclesiastical courts, which had primary jurisdiction over sexual offenses in most of medieval Europe, developed their own approaches to class-differentiated punishment. The standard penalty for fornication, meaning sex between unmarried persons, was public penance followed by a fine. The penance was the same regardless of status: standing in church, confessing the sin, enduring the congregation's judgment. The fine varied enormously. A wealthy fornicator might pay several pounds. A poor fornicator might pay a few pence or nothing at all, the priest understanding that extracting money from poverty merely created resentment. The penance was supposed to be the great equalizer, the moment when rich and poor stood alike in their shame. But even penance could be purchased, indirectly. A wealthy sinner could commute public penance to private penance by paying a larger fine. Instead of standing in church, they might be required to pray certain prayers, make certain pilgrimages, give certain alms, all done quietly without the public spectacle that their poorer fellow sinners endured. The church justified this by arguing that wealthy sinners would be known and whispered about regardless, making public display unnecessary. The effect was that money bought privacy, dignity, and the preservation of reputation. The poor confessed publicly, the rich confessed privately. Both were technically penanced for the same sin. If you just felt that click of recognition, that sense of a pattern you have seen before in different clothing, that is exactly why these stories matter. The subscribe button is right there if you want more of these moments where history suddenly illuminates the present. Prostitution presents an interesting case study in how the fine or flesh system operated when the offense itself was economically motivated. Medieval and early modern towns generally tolerated prostitution while regulating it, licensing it, and taxing it. The women who worked in licensed brothels were technically legal, though socially marginal. The women who worked outside the official system faced penalties that reflected their lack of resources. Unlicensed prostitutes, almost by definition, were poor women without the capital to buy into the licensed trade. Their punishment for working illegally was typically corporal, whipping, carting through the streets, expulsion from the town. The wealthy madams who ran licensed establishments might face fines for regulatory violations, but rarely faced physical punishment. The men who patronized prostitutes faced an even more lenient system. While technical laws against fornication applied to them as well, enforcement was sporadic and punishment was almost always financial rather than physical. A man caught visiting a brothel might be fined a few shillings, a sum that could be paid without serious hardship by anyone wealthy enough to afford prostitutes in the first place. The woman he visited, if unlicensed, might be whipped. The same sexual transaction produced different punishments for each participant, differentiated not just by gender, but by the economic capacity that gender typically correlated with. Rape presents the darkest aspect of this system. Medieval law recognized rape as a serious crime, but the nature of punishment varied based on the social positions of rapist and victim. A commoner who raped a noblewoman faced death or severe mutilation. A nobleman who raped a commoner faced fines, though potentially large ones, and possible exile. A commoner who raped a commoner faced punishment somewhere between these extremes, typically corporal but not capital. The victim status determined the severity of the offense in legal terms. Her body was worth what her family was worth. The payment system for rape included compensation to the victim's family, essentially treating the offense as a form of property damage to the woman's marital value. A raped virgin was worth less on the marriage market, and the rapist owed compensation for this diminished value. The compensation went to her father or guardian, not to her. In some cases, the rapist could resolve the matter entirely by marrying the victim, converting the crime into a legitimate transaction. This seems monstrous to modern sensibilities, but it operated within a logic where women's sexual value was a family asset that could be damaged, repaired, or transferred through legal mechanisms. Property crimes show the fine or flesh distinction with perhaps the greatest clarity, because property crimes were explicitly about money and thus naturally converted to monetary punishments. Theft of goods worth less than a certain threshold was petty larceny, punishable by fines, whipping, branding, or ear cropping, depending on the jurisdiction and the offender's ability to pay restitution. Theft above the threshold was grand larceny, often capital. The poor thief who stole a sheep worth more than the cutoff might hang. The wealthy thief who stole the same sheep could pay compensation, possibly avoiding even the whipping that his poorer counterpart would receive as prelude to the gallows. The concept of composition, meaning the payment of a set sum to settle criminal liability, made this explicit. A thief who could pay the value of the stolen goods plus a penalty to the court could often avoid corporal punishment entirely. The victim was made financially whole, the court received its fees, the offender kept his skin intact. Everyone, except the poor thief who lacked the resources to compose, benefited from this arrangement. The gallows waited for those who could not pay their way around them. Consider the specific case of Thomas Aylward, recorded in the Assize Records of Somerset in 1410. Thomas is a laborer accused of stealing a silver spoon worth 16 pence from his employer. The theft exceeds the 12-pence threshold for grand larceny, making it technically a capital offense. Thomas cannot pay compensation because he has no money, which is why he stole the spoon in the first place. He cannot claim benefit of clergy because he can't read. He cannot appeal to powerful patrons because he has none. Thomas hangs for 16 pence worth of silver, while in the same court session, a merchant's son pays a 2-shilling fine for stealing goods worth considerably more. The merchant's son had resources. Thomas had a rope around his neck. Fraud and commercial crimes developed their own distinctive patterns. The medieval commercial classes, recognizing that their business activities inevitably involved technical violations of various rules, lobbied successfully for treatment that emphasized fines over corporal punishment. A merchant who used false weights might face substantial fines, but rarely face the pillory or worse unless his fraud was egregious and repeated. The argument was that commercial society required flexibility, that harsh physical punishments for business irregularities would destroy trade. The same argument was not extended to the servant who shortchanged customers while working for that merchant. The servant faced the lash. The merchant faced the ledger. Forgery provides a particularly interesting example. Creating false documents was a serious crime, potentially undermining the entire legal and commercial system. When nobles or gentlemen committed forgery, they typically faced fines, loss of offices, social disgrace. When commoners committed forgery, they faced corporal and sometimes capital punishment. The reasoning, insofar as it was articulated, was that a gentleman's word and reputation were already ruined by the accusation, making additional physical punishment unnecessary. A commoner had no reputation to lose, and therefore required physical persuasion to avoid future offenses. The regulation of economic activity produced a constant stream of minor offenses, for which the finer flesh option was exercised thousands of times each year. Selling goods at unapproved markets, forestalling by buying goods before they reached market, engrossing by buying excessive quantities to control supply. These technical violations of market regulations were common and punished differently based on the offender's means. Wealthy merchants paid their fines and factored them into the cost of doing business. Poor vendors who tried the same practices faced the cucking stool or worse. Guild regulations created similar dynamics within craft industries. A master craftsman who violated guild rules, perhaps by taking on too many apprentices or producing substandard goods, faced fines within the guild system. An unlicensed worker who tried to practice a trade without guild membership faced punishment by civil authorities, potentially including corporal penalties. The guild protected its members from the harsher aspects of the legal system while maintaining those harsh aspects for outsiders who threatened guild monopolies. Membership had its privileges, literally. Public order offenses demonstrate the fine or flesh distinction in contexts that went beyond simple economic calculations. Blasphemy, disturbing the peace, insulting officials, these crimes against order and authority were punished with characteristic flexibility. A gentleman who insulted a town official might face a fine and a required apology. A commoner who offered the same insult might face the pillory and the lash. Both had disturbed the peace, but only one had done so from a position of sufficient status to merit financial rather than physical correction. Drunkenness provides a revealing example. Medieval and early modern Europe was awash in alcohol, with ale and wine being safer to drink than water in many contexts. Being drunk was common and unremarkable. Being drunk and disorderly was an offense, but the nature of the disorder mattered enormously. A gentleman who became drunk and broke furniture in a tavern paid for the damage and perhaps a fine for disturbing the peace. A laborer who became drunk and broke the same furniture faced the stocks or worse. The drunkard's status determined whether his loss of control was treated as an expensive embarrassment or a criminal offense requiring physical correction. Religious offenses occupied a special category where the fine or flesh distinction operated with particular complexity. Heresy in its most serious forms was not commutable to fines under any circumstances. Burning was the standard punishment, regardless of the heretic's ability to pay, at least in theory. But lesser religious offenses, such as failure to attend church, working on holy days, or engaging in superstitious practices, were routinely punished through fines for those who could pay and corporal penalties for those who could not. The English recusancy laws, which penalized Catholics for refusing to attend Protestant services, illustrate this dynamic clearly. Wealthy Catholics who refused to conform faced enormous fines, potentially ruinous over time, but maintained their physical safety and personal dignity. Poor Catholics who refused to conform faced imprisonment and corporal punishment. The same religious conviction led to different consequences based entirely on financial capacity. Some could afford their faith. Others could not. Witchcraft accusations show an interesting reversal of the usual pattern. In most jurisdictions, witchcraft was treated as a capital offense, not subject to composition or commutation. The wealthy suspected witch and the poor suspected witch alike faced potential execution, assuming the case proceeded to trial and conviction. But here is where wealth still mattered. Wealthy defendants could hire lawyers, could petition for delays, could appeal to patrons who might intervene on their behalf. Poor defendants faced the full weight of prosecution without resources for defense. The formal equality of the gallows masked substantial inequality in the likelihood of reaching it. The development of imprisonment as a punishment rather than merely a holding status for those awaiting trial created new complexities in the fine or flesh calculus. Prison conditions varied enormously based on what prisoners could pay. Those with means could purchase better food, private rooms, freedom to receive visitors, even permission to leave during the day. Those without means occupied the common cells, eating the prison's meager fare, suffering alongside thieves and murderers regardless of their own offenses. The same sentence of imprisonment could mean bearable discomfort for the wealthy and living hell for the poor. Debtors' prisons institutionalized the absurdity of punishing poverty with confinement that prevented any possibility of earning money to escape. A debtor imprisoned for inability to pay could remain imprisoned indefinitely unless someone outside paid on their behalf. The wealthy debtor's family could ransom them. The poor debtor's family, equally poor, could do nothing. Some debtors died in prison, never having committed any offense except the fundamental crime of lacking money. The system consumed people who were already being consumed by poverty. Military and naval justice developed their own variations on the finer flesh theme. Officers who failed in their duties faced courts-martial that might result in dismissal, loss of rank, fines, or execution, depending on the severity of the failure. Common soldiers and sailors who committed similar failures faced corporal punishment almost automatically. The same cowardice that cost an officer his commission cost a private his skin. Flogging through the fleet, running the gauntlet, keel hauling, these brutal punishments were reserved almost exclusively for those without the status to escape them through financial or political means. Colonial justice in the Americas, the Caribbean, and Asia developed its own permutations based on racial as well as economic hierarchies. European colonists who committed offenses against other Europeans faced familiar European penalties, including the option to pay fines rather than suffer corporal punishment. The same offenses committed against indigenous peoples or enslaved Africans were often not punished at all, or punished with trivial fines that made violence against subject populations essentially free for those with means. Meanwhile, indigenous peoples and enslaved persons who committed offenses against Europeans faced punishments of extreme brutality that no amount of money could have commuted. The slave codes of the Americas represent perhaps the most extreme development of differentiated punishment. Enslaved persons had no legal capacity to own property and therefore no capacity to pay fines. Every offense, no matter how minor, defaulted to physical punishment because no other option existed within the legal framework. Meanwhile, slaveholders who abused or even killed enslaved persons faced at most fines that treated murder as property damage. The same act of killing a human being might be punished with a fine if the killer was free and the victim enslaved, or with brutal execution if the killer was enslaved and the victim free. The fine or flesh distinction had become a racial distinction, with race determining not just the severity of punishment, but the very category of being. By the late 18th and early 19th centuries, reformers across Europe and America were challenging the fundamental premises of this system. Jeremy Bentham, the English philosopher and legal reformer, argued that punishments should be calculated to produce the maximum deterrence at the minimum cost. Fines deterred wealthy offenders more efficiently than corporal punishment, while corporal punishment might be necessary for those whom fines could not affect. But Bentham's utilitarianism still accepted that different punishments for different people might be justified if they produce the same deterrent effect. True equality remained elusive even in reform proposals. The abolition of corporal punishment as a standard criminal penalty proceeded unevenly across different jurisdictions and different categories of offense. England abolished judicial whipping for women before men and for freemen before soldiers and sailors. The United States abolished different corporal punishments at different rates in different states, with some forms persisting into the 20th century. Even as the formal option of fines instead of flesh disappeared, the practical advantages of wealth in the criminal justice system persisted through bail, legal representation, and sentencing discretion. In the final part of this story, we will follow the transformation of the finer flesh system into its modern descendants. Examine how the principle of equality before the law has been reconciled, imperfectly, with the reality of inequality in resources, and ask whether the medieval judge who gave one man lashes and another man a bill was fundamentally different from the modern judge who gives one man prison and another man probation. The question of whether punishment should be equal in form or equal in effect haunts criminal justice systems to this day. And the medieval solutions, brutal as they were, at least had the virtue of honesty about what they were doing. The court records pile up across the centuries, documenting millions of individual decisions about who would pay and who would suffer. These decisions were not random. They followed patterns of class and status that the legal system both reflected and reinforced. To read these records is to watch a machine process in human beings according to rules that treated their bodies as interchangeable with their purses, converting flesh to coin and coin to flesh through calculations that seemed obvious to those making them and seem obvious to us now if only we are willing to look honestly at what we've inherited. The 19th century transforms the finer flesh system, but it does not abolish it. What changes is the language, the justification, the mechanism through which wealth converts to lighter punishment. The explicit privilege of paying to avoid the lash gives way to subtler advantages: better lawyers, sympathetic juries, judicial discretion exercised in favor of the respectable. A well-dressed defendant in a Victorian courtroom faces the same formal laws as a ragged defendant, but somehow the outcomes differ. The conversion rate between money and pain becomes invisible, which makes it no less real. The abolition of most corporal punishment in Western criminal justice systems creates new questions about what should replace it. Prison emerges as the dominant answer, a punishment that theoretically affects rich and poor equally by depriving them of the same liberty. But prison conditions, as we have seen, vary enormously based on what prisoners can afford. And the experience of incarceration affects wealthy defendants and poor defendants differently in ways that extend far beyond the prison walls. A wealthy person can emerge from prison to resume their career, their social connections, their life. A poor person emerges with a criminal record that closes doors already barely open, returning to a community that has not waited for them, facing obstacles that compound rather than diminish over time. The modern fine persists as a criminal penalty, now stripped of its explicit connection to corporal punishment, but still operating according to familiar logic. A speeding ticket costs the same nominal amount regardless of who receives it, but that nominal equality masks practical inequality. For a wealthy driver, a $200 ticket is an annoyance, the cost of driving faster than the law allows. For a poor driver, the same ticket might represent a week's groceries, a utility payment, the difference between making rent and missing it. The equality of the fine assumes an equality of means that does not exist. Some jurisdictions have experimented with day fines, penalties calculated as a percentage of the offender's income rather than as a fixed amount. The theory is that a rich person and a poor person should feel equal pain from their punishment, which requires unequal nominal sums. Finland has used this system for decades, producing headlines when wealthy executives receive speeding tickets exceeding $50,000. The medieval principle of converting pain to money is reversed. Instead of money buying relief from pain, money is calibrated to produce equivalent pain. Whether this represents progress or merely inversion depends on one's perspective. The bail system represents perhaps the most direct descendant of the medieval fine or flesh option. Accused persons awaiting trial can secure their freedom by posting bail, a sum of money that they forfeit if they fail to appear. Those who can post bail wait at home, maintaining their jobs and families and connections. Those who can't post bail wait in jail, losing employment and housing, and sometimes custody of children, all before any determination of guilt. The presumption of innocence coexists with a practical presumption that poverty itself constitutes grounds for pretrial detention. The consequences extend beyond the waiting period. Defendants detained pre-trial are more likely to accept plea bargains, more likely to receive convictions, more likely to receive longer sentences than similarly situated defendants who were released pending trial. The inability to post bail does not formally affect the outcome of the case, but it affects everything around the case in ways that shape outcomes systematically. The medieval defendant who could not pay to avoid the lash received the lash. The modern defendant who cannot pay to avoid detention receives often a worse deal at every subsequent stage of the process. Legal representation provides another mechanism through which wealth converts to lighter punishment. The right to counsel has been recognized in most Western democracies, meaning that defendants who can afford lawyers receive appointed representation. But appointed counsel are overworked, underfunded, and handling caseloads that make thorough defense impossible. The wealthy defendant's private attorney investigates the case, files motions, challenges evidence, negotiates with prosecutors from a position of prepared strength. The poor defendant's appointed attorney, often meeting them for the first time at the hearing, does the best they can with impossible constraints. Same rights on paper, different justice in practice. Sentencing disparities reflect these accumulated advantages. Studies consistently find that defendants who can afford private attorneys receive lighter sentences than defendants with appointed counsel, controlling for the nature of the offense and prior record. Defendants who were released pre-trial receive lighter sentences than defendants who were detained, controlling for other factors. Defendants who appear in court well-dressed and well-spoken, which correlates with socioeconomic status, receive lighter sentences than defendants who present less favorably. The formal factors that sentencing guidelines consider are supposed to be equal. The informal factors that judges and juries perceive are not. Thank you for staying with this story through its complications and modern applications. If this exploration of how wealth has shaped punishment across the centuries has changed how you think about criminal justice, I would be grateful if you subscribed and shared your thoughts. What surprised you most? What made you angry? What connections do you see to cases in the news today? I read every single comment, and your observations genuinely inform where these investigations go next. The corporate criminal justice system represents perhaps the clearest modern parallel to the medieval fine instead of flesh principle. When corporations commit crimes, whether fraud, environmental destruction, wage theft, or negligent homicide, the punishment is almost always financial. Fines, disgorgement of profits, payments to victims, settlements that neither admit nor deny wrongdoing. The individuals who made decisions that would send any natural person to prison rarely face personal consequences. The corporation pays, which means the shareholders pay, which means the costs are distributed so widely that no one feels them as punishment. The justifications offered for corporate criminal leniency echo medieval arguments about why gentlemen shouldn't face the lash. Imprisoning executives would destroy shareholder value. Criminal prosecution would destabilize important industries. The reputational damage of conviction is punishment enough for people of standing. The parallels to medieval claims that gentlemen's honor was already ruined by accusation, making physical punishment unnecessary, are striking. Different centuries, different vocabs, same fundamental argument that people of a certain class deserve different treatment than people of another class. The phenomenon of deferred prosecution agreements and non-prosecution agreements extends this logic even further. Corporations that commit serious crimes can avoid formal charges entirely by paying fines and promising to behave better. No trial, no conviction, no criminal record. The same offenses committed by individuals would produce felony convictions that follow them for life. The corporation pays its way out of consequences that natural persons can't escape regardless of their personal wealth, because corporations exist in a category that transcends individual economics. Consider the specific case of bank fraud. An individual who defrauds a bank of a few $1,000s faces federal prosecution, likely conviction, probably prison time, and permanent collateral consequences, including difficulty finding employment, housing, and credit. A bank that defrauds millions of customers of billions of dollars faces fines that represent a small fraction of the profits generated by the fraud, paid by the institution rather than by the executives who ordered or permitted the fraudulent conduct. The individual cannot pay to avoid consequences. The bank cannot fail to pay to avoid consequences because payment is the only consequence available. The racial dimensions of modern punishment disparities echo the colonial and slave-era patterns we examined earlier. Black defendants in American criminal courts receive longer sentences than white defendants convicted of the same offenses with the same prior records. They're more likely to be detained pre-trial, more likely to face charges rather than diversionary programs, more likely to be sentenced to incarceration rather than probation. These disparities persist after controlling for every factor that sentencing guidelines recognize, suggesting that the informal factors driving judicial decisions operate with systematic racial bias. The intersection of race and class and punishment outcomes produces compounding disadvantages. Poor Black defendants face the accumulated difficulties of poverty in the criminal justice system, plus the additional difficulties of racial bias. They're less likely to post bail, less likely to afford private counsel, less likely to present favorably in court, and more likely to receive harsh sentences at every decision point. The medieval system that allowed wealth to buy relief from physical punishment at least affected only one dimension of inequality. The modern system operates through multiple interlocking dimensions that amplify each other. The criminalization of poverty itself creates a modern version of the medieval treatment of vagrancy. Homeless persons are arrested for sleeping in public, for sitting on sidewalks, for asking for money. They're fined for these offenses, fines they can't pay, and jailed for failure to pay, creating cycles of incarceration that make escape from homelessness increasingly difficult. The fine is technically equal. The inability to pay is treated as a choice, a criminal act of refusing to satisfy one's obligations. The medieval authorities who whipped vagrants at least provided the whipping immediately and sent them on their way. The modern system extracts ongoing punishment for ongoing poverty. Driver's license suspensions for unpaid fines create similar traps. A poor person receives a traffic ticket they can't pay. Their license is suspended for failure to pay. They drive anyway because they can't get to work without driving, and receive additional tickets and suspensions. Eventually, they are jailed, not for the original offense, but for the accumulated consequences of being unable to afford the first penalty. The medieval system of converting unpaid fines to corporal punishment at least ended the matter. The modern system converts unpaid fines to accumulating debt, accumulating penalties, accumulating involvement with a system that consumes people whole. Probation and parole fees represent another mechanism through which poverty converts to incarceration. Released offenders must often pay supervision fees, drug testing fees, electronic monitoring fees. Those who can't pay face violation of their release conditions, which can result in reincarceration. The formal crime is failure to comply with supervision requirements. The practical crime is failure to have money. Thousands of people return to prison each year, not for new offenses, but for poverty-driven failures to meet the financial obligations of being supervised. Cash bail reform efforts represent one attempt to break these patterns. Several American jurisdictions have reduced or eliminated cash bail for many offenses, releasing defendants based on risk assessment rather than ability to pay. The results are contested, with critics arguing that dangerous defendants have been released and supporters arguing that thousands of presumptively innocent people no longer languish in jail for poverty. The debates echo medieval disputes about whether financial penalties adequately deterred crime or merely allowed the wealthy to buy their way out of consequences. The fundamental question that haunts all punishment theory remains unresolved. Should punishment be equal in form, meaning everyone receives the same nominal penalty? Or should punishment be equal in effect, meaning everyone experiences equivalent suffering? The medieval system chose unequal form in pursuit of what it considered equivalent effect, allowing the wealthy to substitute money for pain on the theory that losing money was as punishing for them as losing skin was for the poor. The modern system formally chooses equal form, but produces wildly unequal effect, with the same nominal penalties crushing poor defendants while barely inconveniencing wealthy ones. Neither approach achieves genuine justice. The medieval approach was honest about inequality, building class privilege explicitly into legal codes and judicial practice. The modern approach maintains fictions of equality while producing inequality through mechanisms that are harder to see but no less systematic. Whether honesty or hypocrisy is preferable depends on whether one believes that naming injustice helps address it or merely normalizes it. The medieval peasant knew exactly why the gentleman paid a fine while he received lashes. The modern defendant may never fully understand why their treatment differed from someone else's, only that it did. Some reformers argue for abolishing fines entirely, on the theory that any financial penalty will inevitably fall more heavily on those with less to spare. Others argue for expanding fines as an alternative to incarceration, on the theory that taking money is less destructive than taking liberty. Still others argue for income-based fines that attempt to equalize the pain of punishment across income levels. Each approach has defenders and critics, and none has achieved widespread implementation sufficient to test its effects at scale. The deeper problem may be that criminal justice systems are being asked to do something they can't do. Punishment addresses individual acts but can't address systemic inequalities that shape both the commission of crime and the experience of punishment. A perfectly equal criminal justice system operating in a profoundly unequal society will still produce unequal outcomes because the same punishment means different things to people in different circumstances. The medieval judge who gave different punishments to different classes at least acknowledged this reality. The modern judge who gives the same punishment and calls it equality may be more deluded than enlightened. The story we have traced from Babylon to the present day reveals a persistent pattern. Societies find ways to protect their privileged members from the harsher consequences of their actions while imposing those consequences on the vulnerable. The specific mechanisms change. Weregild gives way to composition, gives way to benefit of clergy, gives way to quality legal representation and prosecutorial discretion. But the underlying dynamic persists. Those with resources to deploy in their defense fare better than those without. The flesh of the poor has always been cheaper than the purses of the rich. What then are we to make of this history? One conclusion is pessimistic. Inequality in punishment reflects inequality in society, and no legal reform can cure what social reform has not addressed. Another conclusion is reformist. Understanding how the current system produces unequal outcomes is the first step toward designing systems that produce more equal outcomes. A third conclusion is radical. The very concept of punishment may be inseparable from the maintenance of social hierarchy, requiring not reform but abolition. Each of these conclusions has advocates and critics, and resolving the debate exceeds what any historical inquiry can accomplish. What history can offer is evidence of how past societies structured punishment, evidence of why they made the choices they made, evidence of consequences that followed. The medieval judge who converted flesh to fines was not stupid or uniquely cruel. He was operating within a system of thought that made his choices seem logical and just. Understanding that system helps us see our own system more clearly, recognizing the logics that make our choices seem logical and just, even as they produce outcomes that might horrify us if we looked at them directly. The court records we have examined in this story represent millions of individual human beings processed through systems that treated their suffering as calculable, their bodies as commutable to currency, their dignity as variable based on their station. Thomas Aylesworth hanged for 16 pence because he lacked the resources to avoid hanging. William the Cooper received 6 strokes because he couldn't pay 6 pence. Agnes paid her 6 pence and vanished into history, her name recorded only because it stood next to William's in the ledger. For every case we can name, thousands more went unrecorded, their flesh purchased cheaply or their purses emptied depending on circumstances they didn't choose. The medieval system at least maintained the fiction that corporal punishment served some purpose beyond economic extraction. The lash was supposed to deter future offenses, to satisfy the victim's desire for visible justice, to mark the offender's body with public evidence of their transgression. These justifications may have been post hoc rationalizations for a system driven primarily by the need to distinguish between classes, but they constituted an attempt at moral reasoning about the purpose of punishment. Modern systems have largely abandoned corporal punishment without developing equally coherent theories of what imprisonment, fines, and other penalties are supposed to accomplish. We speak of deterrence, but the evidence for deterrent effects is mixed and often disappointing. We speak of rehabilitation, but incarceration more often damages than repairs the capacity for productive life. We speak of incapacitation, but most offenders would have aged out of criminal behavior regardless. We speak of retribution, but the retribution extracted from a poor defendant bears no proportion to the retribution extracted from a wealthy defendant for the same offense. The medieval system had its justifications. We have largely abandoned justification in favor of habit, continuing to punish because we have always punished, in ways that happen to reproduce familiar patterns of class advantage. Let me return to where we began. 2 men stand before a judge, accused of the same crime. One walks away with wounds, one walks away with a bill. The judge does not consider this unjust because the law itself makes the distinction, offering options that mean different things to different people. The wealthy man has paid his debt to society in the currency he possesses. The poor man has paid his debt to society in the currency he possesses. Both debts are technically satisfied. Both men are technically equal before the law. The flesh and the fine balance, in the ledger, though they weigh differently in the experience of those who bear them. We live with the descendants of this system, modified but not transformed, hidden but not abolished. The speeding ticket that ruins one family's month while barely registering in another family's budget. The bail that determines whether the accused awaits trial at home or in a cell. The private attorney versus the overworked public defender. The sentence that sends one person to prison and another to probation for crimes that differ only in who committed them. The ledger continues to balance, flesh against coin, pain against payment, consequences against capital. The archives hold their records. Parchment and paper document centuries of calculations. Here, a fine paid. Here, a sentence of lashes. Here, a composition agreed. Here, an execution carried out. The patterns emerge with statistical clarity when enough paces accumulate. Wealth correlates with leniency, poverty correlates with severity, and the correlation is too consistent to be coincidence. The system did what it was designed to do, protecting the privileged and disciplining the vulnerable. Whether our system does the same is a question that the evidence increasingly answers, even if the answer remains officially unspeakable. The night grows late, and the stories of how power has shaped punishment could continue indefinitely. Every society generates its own variations on the theme, its own methods for ensuring that consequences fall unequally on those least equipped to bear them. The fine instead of flesh option was merely one mechanism among many, notable primarily for its explicitness. Modern mechanisms operate through layers of indirection that make the same patterns harder to see, but no less effective. The flesh of the poor remains cheaper than the purses of the rich. The ledger continues to balance. What we do with this knowledge depends on what we believe about justice and what we are willing to demand from our institutions. The medieval judge followed the law of his time, which encoded inequality explicitly. The modern judge follows the law of our time, which encodes equality formally while producing inequality practically. Both claim to serve justice. Both operate within systems that limit what justice can mean. The question is not whether perfect justice is achievable, but whether we can make progress towards something better, learning from the failures of the past without simply repeating them in new forms. Good night, wherever you are watching from. The court records await anyone willing to read them, their evidence available to those with eyes to see. The fine or flesh calculation continues, updated for modern currencies and modern cruelties, as persistent as inequality itself. Until next time, when we will explore another mechanism through which past societies organize themselves in ways that echo uncomfortably into our own era. The ledger closes for tonight. The balance persists. And somewhere, always, someone is learning what their flesh is worth to a system that prices everything, even pain.